Looks like Diddy's going to appeal his case. That's no shock. Want to know more? Hi, my name is Justin Isley. I'm an attorney at the City Law Firm. We are federal criminal appeal lawyers. We're going to cover three things. First, the process, what you can expect for this federal criminal appeal. Second, we're going to cover the potential arguments that they may have on appeal based on what we've heard from the transcripts and the news articles. Third, we're going to talk about potential outcomes. First, let's talk about the process. The most simple and beginning part is a notice of appeal. It's not a complicated document. I'll even put one on the screen. It just says, hey, I want to appeal my case. Let's appeal it. You don't have to give your arguments. It's just a notice that you intend to appeal. That part is easy. After you do the notice of appeal, your attorney enters their appearance at the federal court, which is a higher court of several judges, not the one that you try the case in front of. And the appeal is to review any legal issues. And so the next step is to make sure the transcripts get to that court. After the transcripts have been prepared, there is a briefing order. And this is the order of things. Since Diddy Combs was convicted, he is the appellant. The government, the USA, is the appellee. So it's his job to try to overturn what happened at the trial court below. It will not be uncommon as you guys are following this. There'll be extensions for briefing in this case. They may not ask for them, but it's typical that a couple of extensions are made. And the process goes like this. The opening brief is done by the appellant. In this case, it's Diddy Combs. He will make his arguments. Then, after a period of time, the government, the prosecutors, is going to file what's called a response brief. They get to respond. It's pretty simple. They get to respond to what Diddy says in his arguments. And then the last word, because he has the burden to try to reverse the conviction, Diddy's lawyers get the last word and they get to file a reply. This is usually a very short, very snippy, very sharp brief. And if you're a good appellate lawyer, the reply brief is a really good opportunity to just kind of to make a metaphor, to put the whipped cream on top. You don't want to double your issues. You don't want to repeat what you're saying. You just want to get focused on what the core issue is and pull out the negative or stupid arguments that the government's making. Now, after the briefs are lodged, you're waiting to see if oral argument is going to be given. So a brief talk about what an oral argument is. For those of you who are following this Diddy case, you're going to want to know about these steps. And this might be probably one of the more interesting parts of it. The good thing is, first, the briefs will be available online. We'll share those in the description as they come out. So if you watch this video later on, we'll try to keep the briefs, the opening, the response, and the reply in here. And then we're going to have what's called the oral argument, hopefully. It is very common, although not required, to have oral argument after an appeal of a trial because there are so many serious issues at play. And there are some good ones here. So we would expect, based on our experience, there to be an oral argument scheduled in this case. So what is an oral argument? Well, it's a time that you get to argue your case literally in front of the judges. What is an oral argument? It's a time where you actually get, and this is a appellate lawyer's favorite thing, you get to go in front of the judges and argue. It's not on paper. Appeals lawyers, now we do trials and appeals, so we get to do trials, we get to be in front of people, but for appellate lawyers, the ones that just do the nerdy stuff, and we like the nerdy stuff too, don't get us wrong, this is their time to actually go to court. So it's a lot of work. They'll do a lot of practice in front of people, and they'll do the best they can to make sure they try to predict what the judge might say. What we want as an appellate lawyer is we want interaction. If you go up there and you start arguing with, you're going to get three judges. You won't know who they are. They're going to be up there. You get three judges from the panel, and they may have different points of view than you. They may be tough. But what you want is what we call in the business a hot bench. You may think hearing when we post this link, if you're listening to Diddy's appeal, that the judges fighting with the lawyers is a bad thing, but you want that. What I tell my clients is if the judges aren't questioning you, they're not interested. And if they're not interested, you know what that means? That means they've made up their mind. So have a judge argue with me any day. I'll take that 7 days a week. A hot bench is a good bench. So if the judges are engaged and they're asking questions, that is a good thing. That is not bad. After the oral argument, within a few months, there's going to be a decision. They're going to make a decision whether to affirm the conviction or to reverse. And that's going to lead to our next point, but that's going to be the written decision. We'll also post that in the description as it goes. Now, there could be further appeals to the Supreme Court. That's a whole other video. We may continue this series, but for now, for this purpose, that will be the end of the road for this appeal, this main part. So let's go to the next step. The final step is what could happen as a result of this appeal, right? What could happen? What are some things that can happen on federal appeals? So let's list a few of them. Well, the most simple one is that the appeal gets affirmed. Nothing changes. The conviction stays, the sentence stays, it all stays. That could happen. The other thing that could happen is that the judges could reverse a particular conviction that they have an issue with. Maybe there wasn't enough evidence, but let the other conviction stand. Well, if that happens, they're probably going to have to reverse it to have a resentencing because the judge gave the sentence based on whatever charges they were found guilty of. Another option is that they toss out the whole thing and make him retrial the whole case. That's another option. They could have to retry the whole case from the beginning. The last one we'll talk about that's kind of a result that happened is a reversal just for the sentencing. There are some sentencing issues, and we'll talk about that because we kind of went out of order. But the next topic is going to be potential arguments on the appeal, the actual arguments. But if you win a sentencing argument, but not that the trial was unfair, you may just get a reversal for the sentence, which can also be a win because that gives you a chance to try to reduce the sentence, which could mean that he could get closer back to time served. But his attorney's on the clock because he's getting closer and closer to release. So they're probably going to try to get this appeal done as soon as possible. So let's talk about our last topic. The last topic we're going to cover is potential arguments on appeal based on what we've seen at the trial. The biggest, juiciest issue is the sentencing one. It's really interesting about acquitted conduct. You probably heard this in the news, but we know for a fact that P. Diddy Combs was found not guilty of almost all the serious charges, right? His attorneys beat this case very well in most aspects from a federal criminal defense perspective. But the prosecutors at sentencing, you may have noticed, brought in a lot of the conduct that wasn't even related to the charges at hand. And so his attorney said, look, you can't do this. This is acquitted conduct. This was stuff he was found not guilty of. So I'm going to give you a little history. Let's go real fast. In the olden days, not too long ago, very recent, you could actually go to trial. Let's say you had 10 charges. You beat 5, you're found guilty of 5. In the olden days, for the charges you beat, the 5 you got found not guilty, they could still bring that conduct in, even though you were found not guilty, and enhance your sentence because of it. Isn't that crazy? Isn't that crazy? That's so crazy. But that just changed in the law under the federal sentencing guidelines. I'll even put a link to in the description about how acquitted conduct works. So if you're one of the junkies on this case and you're really interested, you can look at it. So now judges are not supposed to apply acquitted conduct at sentencing to enhance your sentence, but they kind of did that here. It's a good argument by his trial attorneys basically saying, look, a lot of this more serious conduct, the prosecutors are still talking about at sentencing and he's found not guilty of it. And judge, you're using that to give him a longer sentence. If he hadn't had this stuff, if he hadn't had these charges he was found not guilty of considered of, you would have had to give him a much lower sentence. And this is probably one of their better arguments on appeal. I think this is the strongest one and you need to pay attention to it. If he wins this argument, it doesn't necessarily mean the trial will be reversed, but he would get a resentencing. Pay attention. I think this is the one that the judge is going to be most interested in. Okay, let's talk about the other two issues that I think are going to come up. There may be more, but these are the two main ones. One of the main arguments that the defense attorneys made was that this charge, this Mann Act violation, which was typically done for interstate prostitution, his attorneys are saying, look, this is the first time that this charge, this type of federal criminal charge has been applied to any facts like this. It's never been done before. It's not the appropriate situation. These people were consenting. They were adults. It's not the appropriate charge. They got creative because they really wanted to get Diddy Combs. That's going to be one of their big arguments on appeal, and you can certainly going to look for that in their opening brief. Kind of as a scattershot, I don't want to say scattershot, that's not fair. As a kind of a collective, they're going to make a lot of arguments about inflammatory evidence that was admitted to the trial. You object at trial, and any objections that you make at trial, you can raise at appeal. So they've noted in their motion for judgment acquittal, which I'll put a copy of in the description, they've noted that they're going to try to appeal a lot of the evidence that was introduced that they thought was unfair and probably unfairly impacted the jury. So if you like this video on the appeal of P. Diddy's case, Diddy Combs, if you like this video, let us know and we can continue the series as the briefs go in. And we may do a video as each of the briefs come in, the oral argument and the decisions. We're happy to keep you posted. We enjoy federal appellate law. We practice it every day. We're working on a federal appeals brief. Have a great day. See you in the next video.